SJC-11571, Commonwealth v. Tran.
Good morning, Mr. Maven.
Good morning. My name is Steve Nyman. I represent Tran. I did not represent him at the trial. This is an appeal from a first-degree murder case. The defendant was convicted of first-degree murder under two theories: deliberate premeditation and extreme atrocity or cruelty. There are 5 issues raised in my brief. The last one is the 278-33E. I would just like to focus consecutively, if we could, on the first 4 issues.
Can I ask you one question, though, first?
Sure.
The defense here was not lack of criminal responsibility, was it?
It was not, no. And it does get a little bit confusing when you read the testimony of Dr. Krell. I think he, I don't think that the defense was there. I don't think his examination revealed that. It sort of came close in terms of the wording of his testimony, but no, it was, defense was a mental impairment that affected the ability to deliberately premeditate and form requisite malice.
Yep.
The first issue I'd like to discuss, that starts on page 18 of my brief, is the extension, so to speak, of the Tavares instruction. So the reason that in my brief that I put a summary of the facts that were reduced at the motion to suppress is so that the court could have a little bit of a background about what was adduced and perhaps why the issue of the waiver of the Miranda was not an issue that was addressed at the hearing on the motion to suppress. Rather, it was something that became a little bit more apparent at the time of trial.
Can I ask you, is there anything about the Miranda warnings that he received that was erroneous?
Well, we don't know what he read. I think that was the big
We
problem.
have a translation, right?
There-
And
well,
it was all videotaped, right?
There was a translation. The problem with, yes to both, but there was a translation. The translation was not word for word.
Doesn't have to be.
Well, you have to get the key points across, and there was no evidence that the key points did get across. You know, it wasn't long ago that the
What was
Miranda...
missing? What's wrong with what he heard? I'm having trouble, when I read the argument, understanding what was wrong with the Miranda warnings he got.
Well, I think that's the problem here, is that we don't know. And
No,
we know
if you're saying there was something wrong, are you,
That it wasn't-
what's wrong?
that it wasn't conveyed to him word for word. You know, it wasn't long ago that many of the police departments in this state had Miranda cards that all had to be modified because the cards didn't reflect that you are permitted to have a lawyer present with you during questioning. And the during questioning was 2 words that were left out of all the Miranda cards of a significant number of police departments. It wasn't that long ago, 10, 12, maybe 15 years ago. I might be dating myself a little bit. Those 2 words were significant. It was critical. It resulted in
Were they missing here?
we don't know because it wasn't translated word for word. And that was the problem. And it should be translated word for word. And yet one of the interpreters came over, didn't even speak, or I'm sorry, couldn't even read Vietnamese, even though he was a Vietnamese police officer from Boston who spoke it. But he couldn't read it. So you don't know what the defendant in this case was getting. The bigger point is, I would suggest that...
Well, he spoke English and Vietnamese, didn't he?
Spoke them, yes. He just couldn't read Vietnamese.
And what did he say about how he had translated it?
Just that it was not word for word. He translated it, but it was not word for word.
Did he give an equivalent English translation of what he had made?
During his testimony at trial?
Yeah, or on a motion to suppress?
Essentially, yes. More of an outline, but yes.
In his English translation, did that comport with the Miranda requirements?
Not verbatim, no. And I'm not sure it got the whole message across either, and that's one of the concerns here. But it sort of extends to what my request is, and that's that this court extend Tavares and extend the instruction to have the juries consider, and Tavares does suggest that the jury should consider the voluntariness of a waiver when the issue was live. And that's something that was not conveyed to the jury during the judge's charge. They read the model Tavares instruction. I'm suggesting that in the context of this case and prospectively as well, that that instruction should also have language that pertains to the actual voluntariness of the Miranda waiver.
I don't want to beat a dead horse, but if I could just to clarify on the supplemental appendix in the Commonwealth's brief, at Exhibit 12, isn't the underlined portion a translation, as if that's the right word, of the above Vietnamese statements or the translations that were provided to the defendant?
Are you on page 75 of the appendix?
I'm at the brief.
Of the
38, yes, 37, they're all those. Yeah, I've got that wrong, but looks like, so could we, my question is, could we look at those translated underscored portions to get what was told to the defendant?
Oh, sure. I mean, that's what the Commonwealth drew its argument from, absolutely.
Okay. And there's no, you're not claiming that that's an incorrect translation of what was stated to the defendant?
I'm just saying I'm not convinced, based on the cross-examination at trial, that that all was conveyed to him. And that's based on the admission of Officer Nguyen.
Right, but there's no motion for a new trial with you offering testimony from another Vietnamese interpreter saying, I've looked at this Vietnamese language and this does not fairly reflect the Miranda warning.
No, everything for the purpose of this appeal was obviously taken straight from the record.
So I guess among the concerns I have is if we require it to be word for word, I can imagine sitting with interpreters who will say in many languages that is simply not possible, that there may not be the ability in this particular language to say it word for word, that you have to phrase it somewhat differently in order to communicate the same thought. Are we going to be finding ourselves imposing a rule which interpreters may say is impractical in view of the limitations of certain languages?
Well, I understand the court's concern, but I don't know the answer to that question. I do know that, obviously, that the effort here is to have anybody who's accused and provided their rights get the full appreciation of the rights before they waive them, or before they're asked to waive them.
I appreciate that, but your argument, in my view, would be far more compelling if you brought in another Vietnamese interpreter and said, I know what these words mean in Vietnamese and they do not. And here's what they mean, and they mean something quite different from what Miranda would mean in English, but I don't see that here. So I don't know how you can ask us, well, I know how you can ask us. I don't know how you can succeed in asking us to say that it is inadequate in the absence of some basis for us to say that he did not get the gist of the Miranda warning.
And I assume that's not a question.
Well, it is. If you can say, no, Your Honor, there is a good reason why you can do it, and you'll explain to me. But I'm waiting for that.
No, but I can't. No. So you're correct in that regard. My suggestion went a step further, though, obviously, and said that perhaps the trial attorney should have made the argument, and the instruction should have been there, that in order for the jury to consider whether or not the Miranda waiver was voluntary, the instruction should have specified that the jury is to consider whether or not the Miranda waiver was voluntary, and then you bootstrap to that argument about, well, look, they gave him the rights, but not verbatim. It's something for the jury to consider on the issue of voluntariness. And that was the whole point of the argument. Maybe it wasn't articulated well in my brief. I hope.
But let's assume you're right, let's assume that a judge should make some reference to the voluntariness of the Miranda waiver in discussing the voluntariness of a statement. In view of what the jury had before them, was there any reason why the jury would not think that this was apart from your theoretical argument that perhaps the translation was wrong, is there any reason to think that a jury would have been affected by that?
Well, I don't know the answer to that. I suppose it would depend in large part on how persuasive or compelling defense counsel was. If defense counsel were to argue the issue, which she didn't in this particular case, I'm not sure she recognized the issue, or maybe she didn't think that it was something that should be argued. I'm suggesting that based on the response of Officer Nguyen, that it was something should have been argued. If there's no further questions on that issue, if I can proceed to the next issue. That's the issue about mental impairment in the absence of some sort of a definition. And I know the court's been through that before. I tried this, I don't know, maybe about 10 years ago on Commonwealth versus Mercado. But the issue does keep coming up, and the words mental impairment are just thrown in there for the jury to make a decision and equate, well, that with an inability to form malice or deliberate premeditation or to deliberately plan a killing. The jury doesn't really have any understanding as to what mental impairment is until it's given some teeth, until somebody defines mental impairment and goes beyond gratuitously throwing it in there and saying your rights are protected. You were able to avail yourself of, I know it's not diminished capacity, but an option of trying to reduce culpability below first degree or perhaps second degree by showing that there was mental impairment that negated these intents.
But by leaving it somewhat open, doesn't that benefit defendants generally? It allows them some leeway in terms of coming forward with, substance abuse issues, organic brain syndromes, diagnosed mental illnesses, perhaps some other things. Isn't it more favorable to defendants to keep it
Well, I think it's
imprecise?
I think it's great that you keep it imprecise in terms of permitting defendants to formulate defenses around a loose term, so to speak, and embrace just what Your Honor said. So in addition to alcohol or drugs, anything else, or organic issues or anything with the brain. But it has to go a little bit further if the jury's to understand what this encompasses.
Was anything suggested to the judge?
No, as a matter of fact, and that's, again, so I raised this substantial likelihood issue. The defense attorney filed a written request for instructions, and it was the boilerplate model, just use of the word mental impairment, use of the term. But I can't understand.
Could you give us an example of how the judge might have instructed differently?
Well, I sort of did in my brief when I kind of analogized it to the lack of criminal responsibility and said, look, you focus on what this means. You focus on what mental disease is. You focus on what the defect is. You focus on the Commonwealth's burden, which I know this court in Mercado said it's not the same. As a matter of fact, the Commonwealth doesn't have any burden of overcoming that statement.
Are you contemplating that there will be expert testimony?
Well, they're almost always... Well, I shouldn't say, in murder cases, there almost always is expert testimony.
But won't the expert essentially define it for the jury? And if it's admitted, it's on the table right in front of the jury.
Well, it gets to the jury. I'm not sure it gets to the jury with the same effect or impact that it would if it were supported by an instruction. And I mean, some of these instructions I've always argued are not good for the defendant. Some of them are great for the defendant. I've always said the ones that are great are the ones that give the best definition or sort of help the defense, but this doesn't do anything to help the defense in terms of conveying to the jury what this defense really is. It almost comes across as some kind of voodoo. Okay, you said there's mental impairment, but that's nothing.
Was there an expert here?
Yes, there was one expert, and then there was the court clinician who evaluated the
And what
defendant.
was the mental impairment that was being argued to the jury?
Well,
Depression, I
guess
mean, the man had been a military police officer in Vietnam, and then a prisoner of war for 6 years, and then he had these behavioral.
that was the factual underpinning. I guess you talk about
Depression?
emasculation, humiliation, and resulting
So
in
was there a
depression.
diagnosis?
Well, yeah, depression, I guess, was the ultimate diagnosis,
Okay.
predicated on the emasculation, the humiliation, the loss of status in.
Jury heard all of this.
Absolutely. But hearing all of it, and then hearing it from a judge in terms of sort of giving some kind of life or understanding to what was just presented to them, are two completely different things. And I know they're not the same thing, but we do it with criminal responsibility.
Right, but the difference, as your brother points out in his brief, is that once criminal responsibility is raised, the jury has to find beyond a reasonable doubt that he was criminally responsible. So the jury must make a finding as criminal responsibility. For mental impairment, the issue is intent, not, the jury can accept that there was a mental impairment and still find that he also had the intent. So the jury need not make a finding of mental impairment, and so that's a difference between criminal responsibility and mental impairment.
Well, I understand that's what the case law says. I'm not sure it makes sense legally, and that's my argument. Again, I argued it before in Mercado. I know it's come up several times. I don't understand why not. For instance, so when you set forth then mental impairment, and it is in essence a defense, you're trying to reduce a level of responsibility beyond the maximum that the government is looking for in the case. So I don't understand.
Would you like us to rephrase the approach, or rework the approach so that it becomes in fact a recognized defense?
Well, yes. I mean, that's what I asked essentially in the brief, and that's what I've asked for in the past on this.
So we will now have a defense of diminished capacity.
Well, I know the case law says we don't have that, but it can be called something else. But it's, I think in so many ways it really is viewed by lawyers and even judges and certainly jurors, I'd argue.
So how would it work? How would the jury be instructed that?
And I think that would have to, in terms of how you would define mental impairment, that would be something that would be properly formulated based on definitions of mental impairment. But then I think you'd have to be getting into the Commonwealth's burden at that point of proving otherwise beyond a reasonable doubt. Because when you just leave the mental impairment out there, you leave it just as two words, it almost does put the burden on the defendant to say, well, we've raised the defense, and now we have to prove to you this is what it in fact is, if we're going to get you, the jury, to believe it and come back with a second degree or something below that.
Do you have any statistics that suggest that juries don't come back with second-degree murder in cases such as this, where there has been a mental impairment defense, or are the so-called diminished capacity issue is raised?
I don't, but I'm not sure that's even out there. But I think a better statistic would be one that compares with or without an instruction to the jury. So in a state that doesn't have the instruction versus a state that does have the instruction. Because I do not think the jury can ever fully appreciate the gravity or the importance of the defense unless they're told so through a jury instruction by the judge. And it's the way jury instructions are viewed in general. It's the whole history behind it. It's how some judges, give their speeches about the importance of the jury instruction prior to charging them. Some of them have them stand up and say, historically, you used to have to stand through the charge, and there were times when the courtroom doors would be closed and a sign on the jury being charged now, and there is a lot of significance to that. The defendant should have the benefit of that in this particular situation too, rather than forcing him to say, all right, we've got this two-word phrase, mental impairment, but now we got to figure out how to make it work, and we got to come forward and essentially shoulder the burden on that. Now, if I have time, just briefly, the merger issue, I think it sort of speaks for itself. I know the Commonwealth relies on Commonwealth versus Vic. I don't think that Vic at least didn't expressly overrule Boyd. or Santos or Jones. This is one of those cases where the actual act, which was its own separate crime, so to speak, at least in the Commonwealth's analysis of that resulted in a murder, constitutes two particular crimes. It really doesn't. It's really one crime. It's the act of killing somebody with a hammer in a savage way. But it's not a separate crime of assault and battery by means of a dangerous weapon on a person over the age of 60.
You would
Most
agree,
of our-
wouldn't you, that under Vic, the convictions are not duplicative? Under the elements-based test, they're not duplicative.
Under that test, they're not, but I think under Santos, they are, and Vic didn't overrule Santos. I think the same application really for Jones and Boyd, they're both cited in my brief, but you know, most of the murders that are committed in the Commonwealth of Massachusetts are done by means of a dangerous weapon. And that would mean that there will never be a merger of assault and battery by means of a dangerous weapon with murder in Massachusetts anymore, if that's how it's going to be applied. The only distinguishing factor in this particular case, perhaps, is the element of age, because the charge was on a person 60 or over. But I would urge the court to at least distinguish Vic from these particular facts.
Okay, thank you.
Good morning. My name is Michael Kane. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. Just to take up the Vic question to begin with, I would say Vic doesn't overrule Santos, but Anderson follows Vic, and Anderson explicitly, in my view, overrules Santos. Vic itself, the facts of Vic are much more closely related than here. Just to remind the court, Vic involved the single act of raising a gun and firing one shot. And in that case, the charges were armed assault with intent to murder and assault and battery by means of a dangerous weapon resulting in a substantial bodily injury. And in that one act, this court said that those were not duplicative, that the elements-only test was the appropriate test, and that really it's the role of the legislature to define crimes and to further distinct policies by applying separate punishments. I would say even if the court were to apply the pre-Vic law, and this isn't argued in my brief, but I think if you go back and look at those cases, even under the old closely related test, this would not be a duplicative crime. There's abundant evidence this is not a single shot type killing. There were multiple blows, dozens of blows. There was an extended attack. The defendant himself said that he hit her many times. He stopped the attack he interrupted it to gag her with toilet paper and then began again. The medical examiner testified about the number of injuries. They were pre-mortem injuries. They extended all the way from the head to the extremities. If you look at just on the facts, I think a reasonable jury would conclude that this very extended assault involved multiple offenses. And I would direct the court just to Tracy, 50 Mass Appeals Court 435, 2 shots fired within 30 seconds. Maldonado, 429 Mass 502, 2 shots to each victim. Each of those was an assault and battery by means of a dangerous weapon and a murder. And those are sort of pre-Vic cases. As to the voluntariness issue, I just want to clear up a couple of things with the Miranda warnings. The Miranda warnings themselves were complete and accurate. It was the subject of a motion to suppress. The motion to suppress judge had all of the evidence in front of her. The jury had, in fact, identical evidence to what the motion to suppress judge heard, even down to testimony of the police officer who conducted the interview. So that there were really 4 sets of warnings given in parallel to the defendant. He got them written in English and in Vietnamese, and he got them orally in English and in Vietnamese.
Is there anything to indicate that he could read Vietnamese?
Yes, he read them out loud, in fact, and that's the testimony, and that is Essentially, the English-speaking police officer would read from his English version copy, and then the defendant who said he read Vietnamese and he could understand what was written on the page, he would then read them, and he would either read the right aloud, or one of the translator would say, "Does it say on your paper X, Y? You have the right to remain silent." And then he would confirm in Vietnamese, "Yes, it says that," or he would, in fact, with certain of the rights, say specifically what he was reading in Vietnamese. Then a translation of all of that was provided, which is in the Commonwealth's record appendix. The translation was provided by the defendant himself, his attorney obtained the translation. So I don't think that there's any grounds to find any deficiencies here, and the fact that the defendant can't point to any is probably the most telling thing. I would say the presentation here is a whole lot clearer than, the two cases that are on opposite sides here are the Bins case, which involved Portuguese translations, and the Seng case, which involved Khmer. This court held that Bins was satisfactory, even though in that case there were several rights that required 4 repetitions before they were appropriately delivered, and even though there were inconsistencies between the Portuguese translations. This is a very clean translation, and there were no errors that then needed to be corrected in any way. Seng is a quite different case because there was Khmer translations left out 3 of the rights, or incorrectly defined 3 of the rights. And what the court said was that a later English version could not remedy that problem. There was never an error with any of the instructions here. They were all correct. So it's very hard to say where a likelihood of miscarriage of justice could have fallen here. The judge gave the model instruction. He told the jury to consider all of the evidence, which this court has said that minimum is the only requirement in Commonwealth versus Cryer, but the judge here went quite a bit beyond that. He listed particular factors that the jury might consider.
This is on the humane practice instruction.
Yes, Your Honor, it is.
Did he instruct the jury that they could consider whether or not the Miranda warnings had been given on the question of voluntariness?
He did not specifically reference the Miranda warnings, and he could have if it had been requested, but it really is a very detailed instruction that he gave both at the time the statement was introduced and then also at the final charge. Just to list it, he said that the jury could consider the nature of the conversations the police had with the defendant, where the conversations took place, the duration of the conversation, the defendant's physical or mental condition, his intelligence, age, education, experience, sobriety, personality, his degree of attention, degree of whether or not he was confused to any extent. So I think really defense counsel's argument is that perhaps he was confused, not that the translation was incorrect in some way, and the jury had that before them. He didn't limit their consideration in any way. It's very hard to say what the likelihood of miscarriage of justice would be. I would say it's distinctly unlikely that the jury would have concluded differently than the 2 judges who had the issue squarely before them. And when there's no legal basis to make the claim that Miranda wasn't delivered correctly, I don't know how the court could conclude that had the jury squarely been presented the question or specifically been presented the question, they would have ruled or concluded differently. To address the defendant's argument about the diminished capacity or mental impairment instruction, I just want to make clear, and this is in the brief, the model instruction was given 4 times, and it was given precisely at the place where this court's revised instructions, 2013 instructions, says it should be, right alongside the intent required for premeditation, twice in the 2 different parts of extreme atrocity or cruelty, and then one more time in a second-degree instruction. The defendant is suggesting, I guess, that there's a shifting of the burden going on here that isn't present in criminal responsibility, but I think that overlooks the fact that, as Justice Gantz was putting out, neither side needs to prove whether there's a mental impairment. This is a subsidiary consideration. What needs to be proved is that the defendant had the intent required for conviction, and there's no shifting of that. The Commonwealth retains that burden, needs to prove it beyond a reasonable doubt. There are no other subsidiary facts that are ever required to be proved beyond a reasonable doubt, and I don't know that there's been a rationale offered for why this facts should be treated differently. I would also agree with Justice Spina's suggestion that the current treatment, which is wide open, permits the defendant to rely on any condition or any effect. It's hard to imagine that it could be more accommodating. And in fact, it's more accommodating in some ways than the criminal responsibility instruction. The criminal responsibility instruction requires the question, I guess, there is a different burden, but the question for the jury is whether the defendant lacks substantial capacity, which is kind of a much bigger showing or a much bigger, I guess, gap between normal functioning than what would be required here. I think the defendant is really asking the instruction to do more work, but the kind of work that he's asking it to do is left instead to the evidence at trial, to the expert testimony, and to argument by defense counsel. All of that was open to him. It was argued. The defense expert testified on direct examination that he was suffering from acute depression, and that this limited his ability to make choices, that he saw himself in a kind of tunnel vision. That was the testimony that was before the jury, and it was open to defense counsel, and defense counsel tried to argue that meant he could not realistically plan or make choices. It wasn't particularly helpful testimony as to extreme atrocity and cruelty, but then the facts here were so overwhelming, I don't know what would have been. Criminal responsibility really is a different category. I mean, the court has decided that the Commonwealth bears the burden in disproving a lack of criminal responsibility. That's not a constitutional requirement, as the court knows, that in other states is assigned in differing measures to the defense. But criminal responsibility really is different. I mean, if there's a legitimate concern that mental illness means the defendant can't understand his conduct is unlawful or can't conform his behavior to the law, then what the court says is that the criminal law actually doesn't apply, and that there would be a root unfairness in applying the criminal law. The defendant is, in a sense, acting outside the system. But where the issue, as here, is something less than that, it's not unfair. The defendant's condition, whatever it was, did not place him outside the criminal justice system. His mental condition is only relevant to intent, and so it's really a piece of proof like any other. Here, the evidence was, in any event, overwhelming that he had deliberate intent to kill the victim and that he acted with premeditation. I mean, this would be a very strange case to really give serious consideration to changing the mental impairment instruction. The defendant himself said repeatedly, "I planned to kill her and then commit suicide." He explained that he wanted to kill her because of his animus towards her, his anger, years of perceived disrespect, disagreement over finances, his belief that the victim was turning his children against him. And then he detailed his own extensive and careful planning. That was the focus of the whole trial, was his extensive and careful planning. He put together an administrative sort of letter in which he grouped assets for his children, told them about insurance checks on the way, delivered PIN codes for them so they could access bank accounts. He put up signs. He had attempted to electrocute himself after the murder. He put up signs to warn his children and the police. He understood the risks of the electrocution. He waited to be alone with the victim. He said he calmed himself down. He announced, essentially by telephone, shortly before he killed her, he called several people and said, "Come see me tomorrow, there will be a surprise." He went to the basement to get a hammer. He waited to surprise the victim in the bathroom. And in the course of the attack, he paused because of her moaning and started again. The facts really were overwhelming on deliberate intent and premeditation, and even his own expert conceded that. His testimony on cross-examination was frankly devastating. He admitted that the defendant wanted to kill the victim, that he planned the best way in advance, that he made choices in acting, that he knew his attack would cause injury, and that he acted on his intent even though he appreciated that it was wrong and even though he had the ability not to. The evidence was also overwhelming as to the cruel and atrocious nature of the killing. I think it hit every Kunin factor. There were repeated blows, There was great force of the blows, given the evidence of the blood on the walls of the bathroom, the shattering of the bathroom vanity, the disproportion in the length of the attack, the number of the blows, the suffering of the victim. The victim was alive, according to the medical examiner, for every blow to her head. And the defendant's own indifference to her suffering was obvious as well, from his pause to stop the attack because he was disturbed by her moaning and then continuing after that.
Can I ask you a question on an unrelated topic, which we didn't reach with the defendant, but that is the sleeping juror issue?
Yes, Your Honor.
Is there any suggestion that that juror ever deliberated?
No, Your Honor, there's no suggestion that he deliberated. He was named as an alternate juror.
He was named as an alternate, and they never.
No, I think it was they concluded on the same day as closings, I believe. So, and I would just point out that all of the defendant's cases that are cited to suggesting there should have been a voir dire, that all involves deliberating jurors. And I think this case is governed completely by Stokes, which is really almost precisely the facts here. So I would just, in closing, ask the court to affirm the convictions on both grounds. This would not be a case that's appropriate to question the fairness of the existing law. The evidence at trial showed that the defendant understood his circumstances, he considered his options, he thought about the future, he decided what he wanted to do, and what he wanted to do was kill his wife. He made that decision and he acted consistently and carefully with that to carry out the decision. He formulated a plan, he executed a plan, he armed himself with a hammer, and in an extended horrific attack, he struck her repeatedly. He struck her until he killed her, and he didn't stop until he completed what he wanted to do.
Thank you, counsel.
Thank you very much.
Take a morning break.
All right.